Hey everyone, this is Sarah Durham. I'm an attorney at Blizzard and Zimmerman and focus on appeals and post-conviction writs. And today I'm going to answer some of your questions about those very things, appeals and post-conviction writs. So if you would, as you join us, just listen as questions are answered. If you have your own questions, please include them in the chat and we will get to them in the order presented. I'm just going to give another minute or so for people to join in and get their questions down, and then we'll get to it. Okay, let's go ahead and get to some of your questions. And I will begin with, I think the order we got these was Jennifer Davis wrote in and asked, she says, my loved one's attorney wants him to file his own 1107. Where can I get some helpful insights to let him know how to do that properly? And so the question is, if I want to file my own 1107, how do I do that? There are lots of free resources out there. If you've joined us in the past, you've probably heard me mention these things, but Google Scholar is one of those. You just go to Google, type in Scholar, and it will pull up the Google Scholar website. You just change your jurisdiction to Texas, and it will let you look up statutes and case law and all of those things. The statute you want to focus on is Code of Criminal Procedure, Article 11, right? It's in 1107, so that's because it's in Article 1107 of the Code of Criminal Procedure. Also, the form that you're going to need for the application is free, and it can be downloaded off the court's website, texascourts.gov, which is TXCOURTS, texcourts.gov. And so it really is a matter of filing your own writ is not easy, first of all. And it's a matter of kind of synthesizing a lot of information, right? Knowing your case frontwards and backwards, and then of course being able to go and find the law you need, the forms you need, and then how to file it. And we actually, provide a course as well. I'm sure there's other materials out there too that kind of guide people through the process of filing your own writ, and that's always something you can look into as well. We have a second question from anonymous member 438, and they ask, do we have any tips for getting files? The state says it will be at least 6 months. They requested through the Houston Police Department, and they gave me a 2-page summary that has no helpful information. I believe I responded to this on Facebook last night, just basically saying, hey, it is really difficult to get records, especially if you're doing so without an attorney. And so let's talk about that for just a minute. So do I have any tips? Beyond hiring an attorney, not really. I mean, you can do what most people do is file public information requests, and that of course gives the state the state can disclose certain information to you, but they don't have to. The Texas Government Code actually includes a specific portion that says they don't have to provide, the state doesn't have to disclose information to a convicted individual or his family members or her family members. So sometimes a public information request even doesn't get you too far. And then if it does, if the state does give you information, just like this Anonymous 438 said, it might be, kind of unuseful. It's not really helpful information. They give you just a little bit. Or what they give you is highly redacted and it's difficult to make anything out. So again, if you do hire an attorney to prepare a writ, that allows the attorney, a lot of counties provide attorneys with just access to discovery portals. So we can file an appearance into the case, we can access the state's discovery and, review it either at the DA's office or on their digital portals that a lot of counties have. Beyond that, though, the public information request or hiring an attorney, those are really your only two options as far as getting the state's file. Now, police departments and, they'll have their own sheriff's offices. They'll usually have their own public information request forms that you can try to get records from them as well. You're going to kind of run into the same problem some of the time, but it's still worth asking. And a lot of these police departments and agencies have online request forms. So it's just a matter of digging a little bit, looking into the different agencies involved in your case, making those phone calls, and as far as getting transcripts or which are reporters' records or clerk's records, go to your district clerk and request those. I think they're 50 cents a page, so you will have to pay for those, but you will have access to them. Same with reporters' records. If there was no appeal, right, you go directly to the reporter. Well, let me back up. If there was an appeal, the best option would be to go straight to the appellate attorney, because he or she likely has that record on appeal that they can just share with you. Now, if there was no appeal and so there was a plea, so that it's just a plea hearing transcript, maybe some pretrial motion transcripts, you'll have to go directly to that court reporter and ask him or her, for a quote to get copies of those things. Because more than likely they haven't even been created yet. If it was an appeal or if it was a plea, there was no right to appeal. So they would have to create that, and it might be a little more expensive. So public information requests to state agencies, including the prosecutor or the DA's office, go directly to the reporter for the reporter's record, directly to the clerk's office for the clerk's record, and then to those individual police departments, sheriff's offices, and things with public information requests. So I think that about covers that. I will say in the course that we have, we do kind of cover those in a little more detail, but I do find that people trying to get through this on their own do run into a lot of walls when they're trying to get records. So just be aware of that. I don't think it's fair, I don't think it's right, but that is the truth of the matter. Alright, so Shaquille Dene asks, or Shaquille Dene, sorry if I said that wrong, asks, can you go over more about getting DNA run again and how to get the case moved to a different county because of bias within the system? So there's about 3 questions tied into one there. I'll cover them, I'll break it up a little bit. Can you go over more about getting DNA rerun? So if there was DNA involved in the case, right, the way to get DNA tested if it wasn't tested, or if you think there was a problem with the lab or the test results or something like that and you think it does need to be rerun and you have a legitimate basis to ask for that, you want to file what's called a Chapter 64 motion. And the Chapter 64 motion, it can be found in the Code of Criminal Procedure, Chapter 64, and there are certain standards you have to meet, right, in order to get relief on that. So identity has to be an issue in your case, and you have to show that had this DNA evidence been properly presented to a jury by a preponderance of the evidence, which is like a little more likely than not, so like 51% chance that it would have made a difference, that it would have impacted the verdict and the defendant wouldn't have been convicted. So that's kind of a steep standard to meet. So Chapter 64 motions can be difficult. What is good about Chapter 64 motions, they don't count against you in the writ context. So it's separate from a writ. You can file the Chapter 64 because if you then get that DNA evidence through the Chapter 64 motion, that's when you want to use it to file the writ, right? So it comes first, the Chapter 64 motion. And if you if your Chapter 64 motion is denied, you do have the right to appeal that to an intermediate court of appeals. So it's kind of a process, a pretty long process in and of itself. Okay, let's move on to the second part of your question. How to get a case moved to a different county because of bias within the system. So there's kind of a couple of different ways to answer this. The first part, when you're first going to trial, right? If you believe that the judge is biased or that the defendant can't get a fair trial within that county or that jurisdiction, then you want your trial counsel to file a motion for change of venue, right? And that, just like everything else we talk about, it has its own standard, these requirements that you have to meet in order to be able to change your case from this venue to another. So if you're in a really small rural Texas county, you want to move like to Dallas County where, there's not, where people don't know you or whatever. Sometimes it's kind of the opposite. It'll be in a big county with a lot of media coverage or something like that, and people want to move to a different venue. But that's how you do that. It's filing a motion for change of venue. If there's bias within the system, let's say you've already been convicted, right? Because we are talking appeals and post-conviction writs here. You've already been convicted, and you know that your writ is going to be filed in the trial court where you were convicted, right? Maybe you've since found out, and this has happened to us before, that the judge that is going to read and decide or make recommendations on your writ actually defended, one of your co-defendants years ago, right? Because that judge used to be a defense attorney. He has some kind of connection to your case that you think could impact his judgment of your writ, right? Then you would file a motion to recuse, right? So if you just want to get rid of or attempt to get rid of who you believe is a biased judge on the bench, you file a motion to recuse, again, with its own standards that you have to meet in order to be successful. Although sometimes if a judge even thinks, he's like, okay, this party thinks I could be biased, I don't even want to appear biased, so I'll recuse myself, a visiting judge will then take their place, or another judge within the county, and, problem solved. But sometimes the judge won't, right? You file a motion to recuse, the judge doesn't want to recuse themselves, and then it goes to the administrative judge of that region to make that decision as to whether that judge has to recuse him or herself. So that can be kind of a long process in and of itself. None of these things just have really simple answers, as y'all know, but that is the long and short of it. So to completely move your trial from one place to another, that's a change of venue. To get rid of a biased judge, that's a motion to recuse. And then along those lines, if, it kind of stinks because once you've been convicted, and if you're like, well, if my attorney would have filed a motion for change of venue, this all could have turned out differently. Unfortunately, that's not a cognizable ground in a writ, right? My counsel was ineffective because he didn't file a motion for change of venue, unless there is just some, or we've never seen it work, right? Unless there's just some crazy reason out there. I mean, new case law is made all the time, so I won't say it could never happen. But once you've passed that trial point, you've been convicted, that changing venue is kind of out of the question. Okay, Mr. David Kingsley asks a question about an 11072. So let me just clarify real quick and remind everyone, 11072 is filed, it's also a writ, a post-conviction writ, but it's filed after you've been placed on deferred adjudication probation or straight probation. So instead of filing the 1107, you file an 11072. There's no form associated with it. You just prepare and file a brief with your arguments. And then if it is denied, instead of, or it never does go to the Court of Criminal Appeals, it goes straight to the trial court, and if it's denied, you appeal to that intermediate court, right? So it never goes all the way up to the Court of Criminal Appeals. So there is a procedural difference in 1107s and 11072. But David asks for reply brief tips from an order of denial of an 11072 in the First Court of Appeals of Houston. So it sounds like David already filed his 11072 into the trial court, right? The trial court then is actually the one who decides, right? So the trial court doesn't just make a recommendation like in an 1107. In 11072, he or she, that trial judge, makes the decision to grant or deny that 11072. If they deny it, you have the right to appeal that decision to the Intermediate Court of Appeals. So here, David's writ was denied at the trial court level. He appealed it to the First Court of Appeals, and now he's asking for tips as to the reply brief. So he filed his appellant's brief, like his arguments, and the state filed its answer brief, and now he's looking to file a reply brief to the state, which you can do. He says the state brief conflates legal authority, ignores and spins and downplays undeniable legal error from a silent record. So if you can really make a good argument that the state did conflate legal authority, or they're citing to legal authority wrong, they're using it wrong, they're mistaking facts in the record, or they're misinterpreting facts in the record, then that's exactly, precisely when you want to file a reply brief. So the tips I have for filing a reply brief would be: keep it simple, keep it short and simple. Do not reiterate the arguments you made in your appellate's brief. Simply focus on what you want the court to recognize about the state's brief and what you think they did wrong. So again, don't reiterate those same arguments. The court already heard those. They don't need to hear them again. So keep it short, succinct, and to the point as to why you disagree with what the state argued. Let's see. David also said, there was no independent judicial findings of fact and conclusions of law on anything. That's probably a problem. The trial court, when they denied the 11072 in the first place, that usually happens through the findings of fact and conclusions of law followed by an order of denial. So if there were never any findings of fact and conclusions of law, hopefully you argue that on appeal. I'm not really sure how that would go, because I've never seen that the trial court usually makes findings of fact and conclusions of law. That's like a requirement under the statute, under 11072. So maybe you say there's no independent because they relied on the state's proposed findings. That happens all the time, and that's totally legitimate. They can do that. So if that's what you're asking, then there's nothing there. If there were no findings at all, I would challenge that. If maybe include it in your reply brief. If it's, you filed a reply brief and everything's affirmed and your 11072 is still denied, maybe mention the no findings of fact in a motion for rehearing. So that's kind of dependent on what the actual procedural situation is. So David, if you want to follow up on that in the chat, I'm happy to clarify, because I might not be understanding that question very well. All right. Those are the questions we have thus far. And I think we've gotten a few more, or a couple more, since we've been here. Okay. Okay, so Shaquille Dene, you added a little bit more to your question about the DNA, having the DNA rerun. She said the DNA center at the time was known to have cross-contamination. How can you know if the DNA was contaminated? That's a good question, and that might not even be, I don't know. I mean, we've questioned DNA interpretation and DNA analysts and how they testify about DNA results before, and we've kind of thrown that under, sometimes actually in one writ we presented it as false testimony because the DNA analyst presented what we thought was kind of a confusing picture to the jury of the DNA results. I don't know that your case quite gets there. You're talking about possible cross-contamination. I don't know. You would have to, there should be reports out there if the lab is known for cross-contamination. I know I just recently came across a case where the DNA analyst actually had a page in the report, right? There was a Brady notice on the last page of the report showing that DNA analyst had cross-contaminated samples like in the year 2022, right? Well, I look at that, I'm like, well, trial counsel should have asked the analyst about that, right? It was part of the record, it was part of the report, and in his cross-examination of that analyst, he could have asked him, do you have this history of, cross-contamination. Here in the report it talks about that happened. Can you explain that to us, like what happened? Because I think it's good for the jury to hear, right, that this DNA analyst who's presenting themselves as a capable scientist with results you can rely on made some pretty big screw-ups a couple of years prior. That's important to know. And if you had a similar situation, perhaps you can bring that in under an ineffective assistance of counsel for failure to cross-examine and, basically bring out that information to the jury to where they would question, and rightly so, the credibility of the DNA analyst or the serologist or whoever it is that they're questioning. Charlotte Renee asks, so what if there was no DNA testing found? That's a good question too. So maybe, and I'm kind of going to interpret my own facts here. If there was, or there should have been DNA and there was no DNA collected, you're kind of, stuck, right? Now, if there was DNA collected but no testing performed, that's perfect fodder for a Chapter 64 motion, right? We have had that happen, and we filed a Chapter 64 on that, where DNA was collected, and we argued that our client's identity was in question. The DNA should have been tested, because had it shown to be someone else, it would have, our client could not have been convicted had it shown that it was someone else. So if there was no DNA testing done, or no DNA testing found that was done, right, you're kind of in the same situation. So you definitely want to follow up on that, because if the DNA samples that were taken still exist, right, you can get those run through a Chapter 64 motion, again, if you meet those requirements, right? Identity was in question, and by preponderance you can show that the DNA results could show that your client wouldn't have been convicted had they been known to the jury. Okay, Shaquille, you added, he was also a minor when this apparently happened, but they came to him years later when he was an adult. He's been down 20 years in TDCJ, will only accept 17 years. And since he pled, he said he's okay with the charge, he just doesn't think the time he got is correct. If he was a minor when he committed the offense, that should have been, he should have had to go through a certification process, right? Even if they come at him, 7 years, 6 years, 5 years later, but the offense was committed when he was a minor, there still has to be still has to be certified as an adult, which is kind of weird, right, when you're certifying a 24-year-old as an adult or something. But that's the process it has to go through. So if that never happened, there could be like a whole nother issue to his case. And then it sounds like he said he pled, that he's okay with the charge, just doesn't think he got, thinks he got too much time. Just from a writ perspective, that sounds like an involuntary plea, right? And then you want to show that, there are things that he didn't know, that had he known, he would have decided to go to trial instead of plead guilty. Usually that whole, I didn't know this, or I was coerced, or I didn't understand the facts or the law of my case, you can strap that to an ineffective assistance of counsel claim. And because of my trial counsel's ineffectiveness, my plea was involuntary, and I would have gone to trial had I, known that there was someone else implicated in the crime, or that DNA existed that was never tested, or whatever the case may be. You have to show that your plea was involuntary, that you would have gone to trial had you been informed of everything you should have been informed of before you pled guilty. Yeah, Shaquille, you say that didn't happen, it was like 10 years later. Scared him that he would get life. That happens a lot, the DAs threaten life, right? Because it does, a first-degree felony, any first-degree felony, the range of sentence is from 5 to 99 years or life, right? So 5 years to life in prison. So if you have a first-degree felony and you're facing trial on a first-degree felony, it's really easy to use that as an incentive to a defendant to plead guilty because, you know, you can say, well, if you go to this jury, it's possible you could get life, and that's not a lie, right? Anytime the DA says that, that's a true statement. So now it's up to trial counsel to talk about the strength of the defense and their chances at trial, right? That's what it's all about. So again, there could be something there that, you know, that defense could have, you know, given him a strong defense at trial or something to that effect. But it is important that the communication between trial counsel and defendant was there, and that defendant was fully informed of the discovery, any possible defenses he could assert, kind of the strength of those defenses. You know, that's what the legal system's made of. So if those things didn't happen, right, then that's why people file writs, right, and they assert involuntary plea all the time, right? And the courts have said, and I've said this before, you know, in Ex parte Thule, it's a kind of a landmark case where the Court of Criminal Appeals said, you know, people plead guilty for all kinds of reasons, not just because they're guilty, right? They plead guilty to get out of jail, to get back to their jobs, to get back to their families. There's a whole variety of reasons they do plead guilty, and it has nothing to do with whether they did what they're charged with doing. So the court is aware of that, and so it makes those involuntary plea claims a little, I think, more legitimate to the courts, because they do kind of have that in mind. So you just have to show, right, that there were problems with your case, problems with the way your counsel handled it. We've had a case where we showed that on the record it was discussed that he was pleading guilty to and was accepting 5 years, but they basically said you'd only have to serve half of that 5 years. Well, the statute said you have to serve all of the 5 years. There's no possibility to be eligible for parole anytime before that. And because my client was placed under this false, you know, I'm not sure what word I'm looking for, but he was told that he would be out in 2.5 years rather than 5. You know, he accepted the terms under those, or accepted the plea bargain under those terms. And so the Court of Criminal Appeals was like, no, that was involuntary, because he was told wrong on the record by the judge, by the state, and by defense. And so he was able to, that conviction was reversed, and he was then placed on probation and is doing great. And if I told you that story before and you've heard it before, I apologize, but it's one of our favorite successes. And it shows that the system and the 1107s can work. All right, I think I skipped some of these. All right, Carly Blue asks, is there any way to get the reporter's record for pretrial settings if the case never went to trial? Harris County keeps telling me to call, email different people. Oh, Harris County. The answer is yes. Pretrial settings, especially if it was something like a motion to suppress, right? Even if someone pleads guilty, they have the right to appeal from pretrial motion decisions. So if you have a motion to suppress, it was denied, you end up pleading guilty, the denial of that motion to suppress is still open to appeal. So the reporter would still have her notes from those hearings and be able to provide those, you know, upon request. As far as calling and emailing different people, again, I'd try to go straight to the source. If you could go straight to that reporter and get those pretrial hearings. Again, she probably just has her notes from those. The transcripts were never created because the plea of guilty. And as I'm learning in Harris County, and y'all correct me out there if I'm wrong, but at least in a couple of cases we've gotten recently, there are no, or the plea hearings are not recorded, right? So I'm not sure if that affects pretrial stuff too. That could be a possibility, but please, I don't know why, but they're just not included. They don't have court reporters that record them. So when I go to get a transcript of a plea in Harris County, I'm told, well, that wasn't even recorded. And so, working through that problem as we speak. I'll keep y'all updated on that. So Shaquille says the same. She's in Garza County. No one can get the reporters to answer to get transcripts. I will say reporters are hard to get a hold of because they're constantly in court, right? They're recording all kinds of hearings and trials, and if they're in a trial, forget it. You're not going to probably talk to them for a week or two because they stay really busy. But leave messages. You can email them if the case did go to was able to be appealed, then that means, again, go to that appellate counsel and try to get the transcripts from him or her. Or if you can't get them from the appellate counsel, you can't get them from the reporter, him or herself, ask the Court of Appeals. So you can call them, you can send them a letter, and as long as you can show them, look, I've done my due diligence, I've tried to get it from the reporter, I've tried to get it from this attorney, and no one will give it to me. You will still have to pay for it, but the Court of Appeals can give you that record as well. Also, there are some things, back to that website that I told y'all about earlier, texcourts.gov, txcourts.gov. Some of the portions of the reporter's, not the reporter's record, but the record on appeal will be available on that website. Not the reporter's record, not the clerk's record, but the briefs that are filed, the appellant's brief, state's brief, any reply briefs, ultimately the opinion from the Court of Appeals, all of that will be linked on that page. Once you go to the texascourts.gov, go to the right court that it's in. Like, for instance, a lot of our appeals around here go to the 11th Court in Eastland. I click on 11th Court, case search, put in my client's name, all the cases will pop up. Click on the case that you want, and then all of these PDFs of the things filed into the case, of those aforementioned things, the briefs, the opinion, will be there and available for you to click on and download. So that's a really helpful resource, I think, for everyone. We use it all the time too, especially when we get these writ cases and we need to see some past, the past appeal and what all happened. So keep that in mind too. Always, that texascourts.gov is just a really rich resource full of all kinds of stuff that you can teach yourself about writs, all kinds of forms, information on the courts, their statistics, if you're interested in that, on how many habeas applications were filed in 2023, how many were granted, those kinds of things. I think they're only up to like 2024. Yeah, so it takes a little bit for the statistics to get posted, and kind of difficult to wade through, but they're there if you're interested. All right, let's see. I think I'm through. All right, Shaquille asked, how can you get the reporter's record if no one can find the reporter? We've run into that too. I mean, reporters retire just like anyone else. They move to Mexico and they're done, right? They don't want to mess with being a reporter anymore. So if you can't find the reporter, that could be just, you're not going to be able to get a hold of those transcripts, but think about those other people who might have it, the appellate attorney, the Court of Appeals. If the reporter was the only one with it and you can't get a hold of that reporter, you can at least ask the current reporter if they have any access to that reporter's old notes, right? If they left, an archive of their old reporting notes, even if they don't have the transcripts themselves. Did they leave the notes that could then be transcribed? So you can ask those questions as well. And just because they're not reporters anymore and aren't at that county or aren't even working as a court reporter anymore, a lot of them will still save their files. Now, they're going to charge you a lot for it, but as long as you can reach them, I think you have a, okay chance of getting those transcripts. Shaquille brings up a good point too. She says this case is over 20 years old. They didn't have emails. They don't know that the numbers of the reporters, even if he pled, that they can give it to me at the appeal level. Right. That's kind of what we talked about. And the age of a case, we're talking about, 1107s and post-conviction world. Some of these cases do get old, right? We have cases 5, 10, 15, 20, as in Shaquille's case, 20 years old cases. And the older they are, of course, the more difficult it becomes to get a hold of those transcripts, because those reporters have since moved on to do other things. A lot of the, we've gotten some paper transcripts before that courts of appeals who haven't digitized everything were able to share with us. But a lot of I think most of them, for the most part, are, have gone through these kind of digitizing projects to where they have most of everything for pretty far back digitized and able to share those on a CD or what have you. Let's see. All right, I think that's all the questions that I have in the queue. I will wait for just a minute or two more to see if we get any more. Y'all can always, if you've ever joined us before, you know that if questions come up while you're working on your loved one's writ, or your loved one has questions about a writ, or even an appeal, a direct appeal, or a PDR, you can send us questions at appeals@blizzardlawfirm.com, and we go through those every morning, and we can answer those quickly for you. Just questions like this, like questions about reporters' records, or who do you ask for what. I mean, those are pretty simple for us to answer, so we're happy to help you in that regard. And again, that's appeals, APPEALS, @blizzardlawfirm.com. Remember the texascourts.gov website, the Google Scholar website. Again, if you're doing some research, that is a great place for you to go to access case law, to access statutes, and it's all for free. Just remember to change your jurisdiction, or make sure your jurisdiction is Texas, because you only want to be focusing on Texas case law or Supreme Court of the United States case law. So make sure you're narrowing your focus. You cite to like Illinois or Iowa, Ohio case law. Texas courts don't care. Okay. All right, I think that's all the questions we're going to get to today. So thank y'all so much for joining. Thank you for sending your questions in. We will do another Facebook Live in a month or so. So just be thinking about those questions, save them up, send them in, and we'll answer them when that time comes. So I wish y'all the best of luck in your post-conviction pursuits. And until next time, thanks.